price on the table, but I think your questions are more important if you have some that are related to the content of Julie's speech or regulation in general. And if you... This musical chairs. Could you get the music going, please? Okay. Any questions from the floor? Go ahead. Can we have a microphone over here, please? Or if you start off, we won't wait. You start off and I'll... Oh, there we are.
Now, there's been a lot of reference in the United States recently to black swan events. And one situation in Canada which might give rise to that kind of event would be an earthquake in British Columbia or Quebec. And I'm just wondering whether the discussion paper that OSFI is going to come up with will address the topic of black swan type events and reinsurance and the appropriate levels that companies should buy to protect their assets.
Okay, you don't care who answers that question, do you?
Nope.
Okay. Any of you like to take a shot at that?
No.
Go right ahead. Next question.
Being a daring man, I will commence to try to answer it. I think the two subjects are separate. Excuse me. In other words, I believe that OSFI has its hands full with a thorough reinsurance regulatory review, and you heard Julie's comments in that regard. And while there are all kinds of risks that could be talked about in relation to reinsurance, and certainly that one would be near the top of a list, I think that they really have to look at that separately. And it would be taking on too much if they not only do the reinsurance regulatory review and all the rationale for the way it should be, but then look at particular risks in that regard. I think they then have to go to the separate study of separate topics, separate adequate reserving and capitalization, and just separate research and release of papers.
Do either of you have any further comment on that?
I think that the only thing that I'd add with respect to that is I think the discussion paper, we would expect that all types of risks would be considered and taken into account in coming up with suggestions or recommendations, if that's what it's going to do with respect to regulation of reinsurance going forward into the future.
Yeah, and I think we have to wait to see what's in the paper to get a feeling, in a sense, where OSFI is going to go. There's been lots of discussion over the years about where we'd like it to go or where the industry would like it to go. And I think we have to figure out whether that meshes before we take any next steps.
Other questions? Okay, I have one I'm going to pose maybe to Robert, since you were the first volunteer the last time. What are the differences the recent amendments of the Insurance Companies Act brought to M&A acquisitions, including transfer of insurance policies, assumption reinsurance, or indemnity reinsurance, and their impact on P&C companies in particular?
We hope that this is an issue of broad interest. I will be brief. In a nutshell, the type of M&A we're referring to is portfolio transfers, indemnity insurance, and assumption reinsurance, as opposed to the other two kinds of M&A transactions, which are share acquisitions and amalgamations. And it's very interesting what they did in this area of these three. To recap briefly, portfolio transfer, of course, is where one insurance company, the cedent, transfers the policy to the assuming company, but has the policyholder consent. So, of course, that's going to be an unusual case because you're only talking about a handful of policies where it's manageable to get policyholder consent. Perhaps a reinsurance or a transaction or an unusual direct one. So you don't really need to think about having to have approval. On the other hand, you need some kind of review. And so the regulator can, in that regard, require that the companies provide such material as makes sense in the circumstances. I think it's a very flexible and realistic approach to these kinds of transfers, whereas previously you needed approvals. On indemnity reinsurance, that too had to be requiring approvals for both the transferring or the cedent and the reinsurer by both parties if it was out of the ordinary course. The big issue, of course, was what is out of the ordinary course. I'm sure many, if not all of you, have had experience in that regard, and it's really a judgment call in many cases, what's in the ordinary course, what's out of the ordinary course, and therefore whether you need an approval. Wisely, that issue has been done away with. You no longer need approvals for indemnity reinsurance. Of course, remembering the fundamental point that the policies aren't transferring. They're staying with the cedent. It's also worthy to mention that the rationale for doing that change is that risk management policies and capital adequacy and management policies generally have been so strengthened over the years that you no longer needed to be as concerned about those kinds of transactions for the reasons you would all know. On assumption reinsurance, this is a case where there are approvals required because while the policies are being transferred from one company to the other, the policyholders, which is somewhat uniquely Canadian, do not have to consent. There is proper notice and advertising and objection periods and the rest of it. But it's still a case where there's a regulatory approval for the cedent company, but not the assuming company. And the rationale there is that you're going to have the company that wants to do the transfer prove that it's in the best interest of the policyholders, have an independent actuarial report, which we're used to now. So in a nutshell, for good reasons, there's been quite a bit of reduction in regulation, and it is easier to do any number of transactions. And it is also worthy to consider what kind of transaction you want to do and what you might want to accomplish by working with those rules. That's on the good news side. Later, we might talk about where's this world going with all we know that's happening with regulation, whether it might be more.
Okay, I would suggest that you've got, if we combine the hourly billing rates of these three gentlemen up here, it far exceeds the monthly lease payments of anybody's car in the room. And so you've got some free legal advice here if you have some tough questions for these guys. If not, I have a couple more.
Greg?
George.
Can I
Oh,
just
sorry,
George.
just a minute. You go
I
ahead
just wanted
first,
to follow
Robert.
up on what Robert said. I suspect that the proposed changes to Part 13 may have reinsurers that were looking to enter Canada taking a second look at that. Because if you use the old model where you have a chief agent and nobody else in Canada and all your business is underwritten and managed outside of Canada, that business will not be admitted business under the new rules. And so companies that were going to use that model may well say, we're not going to use that model, we're not going to look at entering Canada. That may or may not be dealt with in the reinsurance paper that's coming out. So,
Thank you, Crawford. George?
Thank you. Passing up the opportunity to ask a somewhat unfair question to a group of lawyers is something that is hard for me to do. I should note, Greg, that their rate compared to I drive an old car. I think it's well in excess of the lease payments. The reason I suggest this is somewhat unfair is because I'm really asking for your views in terms of something that I think logically might flow out of the remarks that Julie made. But in her remarks, she certainly, as Joel did this morning, I think raised some concerns about certain aspects of our business, and with the things like the circumstances in Alberta around their constitutional challenge, the fact that it's seemed to getting some legs in Atlantic Canada, the deterioration in Ontario auto and property results, the softness of markets, etc. Listening to Julie and not wanting to characterize her remarks unfairly, and I'm thrilled that she's suggested there's some room for some modeling exercises in DCAT. I'd also note that the pundits in the States characterize the problems in the States as the failure of the model. So whereas some may cast some faith in DCAT, I'm not one of them at the moment in terms of providing the answers to this dilemma on a timely basis. I guess the question I would ask you, and noting that the provincial regulators are coming tomorrow, so I hope they're listening, have you got any suggestions, recommendations, or thoughts as to what things OSFI might do proactively that would not be overwhelmingly inconsistent with its mandate to help, if you will, in this regard?
Thank you, George. And the challenge is to try and make your response shorter than the question. anybody
I'll
want to
start if
try
you
a
want.
stab at that one?
George, perhaps an unbelievable answer. It's only a question in my mind about, precisely how you do it with finesse. You just can't pull together everybody in the room on this issue because it's the people of the province that really drive this agenda, as I think we know, and how politicians feel that they have to react, or depending on your view, overreact. And so I really think that the right players, not just OSFI, have to think about, frankly, a very organized government relations approach. I really think it's a question of education and communication, and obviously the explanation of impacts. And of course the problem is that governments and ministers keep changing. But I think you have to create and execute a concerted government relations type plan, which is anticipate every key figure in the key provinces that you have to approach and talk to them about the impact on this so that they are more educated and can take a more responsible approach rather than a sometimes too popular, unthoughtful one.
Anybody else got any further comments on that? If not, then I've got another question. Crawford, this one's... Sorry?
Sorry, just a short follow-up. Robert, we're doing that in the industry today. But I really, in the context of what about the role of the prudential regulator? Roughly two-thirds of the people in this room, if it's representative of the market, are regulated prudentially in Ottawa. The other third are right within the provinces. But do they sit back and just account for the fact that there's a problem, or do they proactively intervene in some way? And you guys understand their mandates better than some of the rest of us in the room, and I'm really looking for an opinion.
No, I certainly agree with the observation. OSFI has a role. All I was trying to suggest on that point was that I just don't think they should be put front and center on it. But they should be a key communicator in terms of what the financial implications are for the consumer. This public that somebody wants to protect by their rights to claim for damages, et cetera, on any number of grounds, have to be balanced against what's in the greater interests about solid companies that can pay policyholders in great numbers for many claims across the board. And that just doesn't come out in the discussion. So there's no question OSFI should have one of the leadership roles.
Okay, Gord, this is a question for you. Having regard to recent concerns with respect to the financial world markets and the adverse developments in the U.S. highlighted by the circumstances of Lehman Brothers, AIG, and Washington Mutual, and others, should the Office of the Superintendent of Financial Institutions have a more public face and a more visible role in informing and reassuring Canadians?
I think there is an opportunity for OSFI to have a greater role in dealing with the public and providing comfort and reassurance and confidence in Canadian financial institutions. I think it was Joel mentioned this morning that we've got what amounts to sort of a catastrophic sort of world financial situation, and Don Drummond in his comments was commenting on the significant impact that the U.S. markets have on Canada. Much of Don's talk really was U.S. focused and the significant impact that their markets have on ours. All the same, in Canada, we have Canadian regulated financial institutions. OSFI is charged with responsibility for supervising those financial institutions. It does a good job. I don't think that it's always communicated to the public as well as it could be how good a regulatory oversight function OSFI serves and the protection that they provide to Canadians. A mandate, significant mandate of OSFI is to contribute to public confidence in the Canadian financial system. And there is, I think, concern among Canadians with respect to financial markets now. The concerns in the states that haven't yet materialized here, and I don't think people expect to materialize here, still are being felt by Canadians. And we've had, for instance, clients call us to check into whether the funds that they're holding in trust with us, which are often in significant amounts, are safe in the financial institutions in which we have them deposited. And I think that's something that really hasn't happened in known memory. There's a distinction between, I think, the health of financial markets, and everyone's got concerns with financial markets these days, from health of our financial institutions. And as Julie commented on in her remarks today, our financial institutions, for the most part, are well capitalized, have capital to weather the storms for the most part. There's a lot of uncertainty on the horizon. No one knows what the next announcement is going to be, if there is going to be an announcement of another failure. But in Canada, I think we are well regulated, and there really isn't a regulatory voice other than OSFI that can provide that sort of confidence and comfort going forward to the public.
Here's a question. Doug? We need a microphone over here.
As a retired claim manager, I was very interested in the comments that were made by Julie with respect to the reserving policies of companies relating to the Whitman decision and what effect it may have across the country with some of these other jurisdictions with thresholds. She suggested that the insurer should be looking at their reserves. I don't know whether she was suggesting they should get out every file where there's a reserve based on there being a threshold and bump it, or whether they should leave it to the IBNRs. So I just wondered if any of these gentlemen have any comments of what the insurer should be doing in that respect.
You understand the question in terms of anybody want to volunteer?
I'll jump in because Robert generally has to, and we've got to give him a break for a moment. I think it's primarily an actuarial question to start with, and it's up to the actuaries to, for the individual companies to look at their reserving practices and make sure that they're providing appropriate reserves in respect of uncertain events. There is an uncertain climate created by the Alberta decision, and it's something that has to be taken into account properly. I think Julie commented on the differences that actuaries seem to be taking with respect to reserving practices in light of the decision, and that causes some concern for OSFI, and so it's something that they're going to be focusing on. At the end of the day, though, I think it's something that is going to be up to the appointed actuary for each company to make an appropriate determination with respect to what reserving practices should be followed in light of the decision.
I also think that that's probably a question for the board at the board level, making sure that the actuaries are doing this, whether there are any instructions from OSFI or from the CIA to take a look at this. I think boards and their whole concept of effective risk management should also be asking their actuaries to do this.
Crawford, how about a direct question for you? In light of the recent discussions regarding a national securities regulator, would it be appropriate to have a single national insurance regulator?
Appropriate is perhaps not the right word. I think that would keep George happy. But it's an interesting question. Obviously, there are lots of mights and maybes and perhapses that go into this. But if Mr. Flaherty or his successor is ever able to institute a national securities regulator, then the die seems to be moving that perhaps we should also have a national insurance regulator. Now, that would create a bunch of issues. Certainly, there are constitutional issues that would come to mind. But there might be some benefits. You'd have consistency, hopefully, not only at the level that OSFI currently regulates, but also in the market conduct area. That would put a lot of strain on OSFI, I think, to get ready to do that, because there'd have to be a lot of knowledge built by OSFI to be able to take that on. I would think that the provinces typically would say, no, we know how we want companies to act in our province. And so that would certainly be something that the provinces would put forward. Will it ever happen? Well, since I'm going to be working till at least I'm 75 or 80, I hope it does, because then I would enjoy working with Robert and Gordon on this.
Well, you took the same hit to your portfolio as I did to mine, obviously.
What portfolio?
Other questions? You're letting these guys off pretty lightly. No more? Okay, ladies and gentlemen, then I'd just like to thank the three distinguished gentlemen up here for, on very short notice, coming up to answer our questions. And on behalf of all of you and on behalf of the National Insurance Conference, I present you each